Well, okay, ladies and gentlemen, thanks for attending this section on the topic of mechanism seeking war damage compensation for foreign direct investment. I'm Zhu Guanwei. I graduated from King's College London with a master's degree of law in international dispute resolutions. I have been a practitioner in the legal industry for years. So before I move to the context of my research, I would first like to introduce why I did research in this topic and wrote this paper. So in this year, 2022, I switched from law firm to a multinational company which invested in many locations of the world. Shortly after that, the Russian-Ukraine conflict broke out and it is still ongoing by the time I record this video. That drives me to think about what if our investments in overseas countries is destroyed in a war or armed conflicts and reparation is out of choice. Well, the answer naturally comes as seeking war damage compensations, which I will present to you from here. So seeking war damage compensation is in essence a dispute resolution because relevant states are unlikely to just give what the foreign investor demands or requires. Well, there are 6 ways or 6 mechanisms of dispute resolution, namely negotiation, mediation, inquiry, conciliation, litigation, and investment arbitration. Among them, negotiation, mediation, inquiry, and conciliations are sometimes referred to collectively as diplomatic methods or amicable methods, while litigation and investment arbitrations are sometimes called legal methods. So we will first look at negotiations. Negotiation is the direct interactions between parties in disputes. In this context, they are foreign investors and relevant sovereign states. Negotiation can occur in any stages of seeking war damage compensations. It can be the very first steps, or it can happen in the very last minutes. One thing needs to be noticed, however, is that it has now become a common mandatory prerequisite of investment arbitrations because more and more bilateral investment treaties adopt an escalation structure of dispute resolutions, which means that under more and more bilateral investment treaties, parties are required to first employ a certain mechanism before they can turn to another one. Then next, we'll move to mediations. Mediation somehow can be regarded as negotiation with facilitation from a third party. There has been a gradual trend of using mediation to resolve investment-related disputes, so including seeking war damage compensations. Negotiation and mediation share many features in common. For example, results achieved from mediation or negotiations can be incorporated into arbitral awards. So, for example, if there is an investment arbitrations and the parties in the arbitration resolve their disputes via a negotiation, they can ask the results to be written into the arbitral awards. Well, also, some laws or treaties may impose certain requirements of the normative process of doing negotiation or mediation. For example, in relation to the how notice should be sent, should be delivered, how to manage time limits, and etc. etc. Well, there are also 2 other types of amicable dispute resolutions, which, as I previously told you, inquiry and conciliations. They are by nature more suitable for disputes between sovereign states. So in my research under the current topics, I didn't analyze them in details. Then we should move to legal methods. First, litigations. Litigations can commence before the course of the whole state. Well, there, but the issues of state immunity were raised. So state immunity means that the state is immune from certain legal proceedings before the courts of other states. There are two doctrines of state immunity. One is the absolute doctrine and the other is the restrictive doctrine. In the circumstance or either these doctrines were applied, so it caused an extra trouble to the claiming foreign investors. Well, however, there is a recent development that worth noticing. The Italian court find that if the war constitutes a violation of human rights, then state immunity can be reasonably denied. Well, on the other hand, the claiming foreign investors can also turn to the court of the invading state and thus avoid the issues of state immunity. Well, however, in this case, the foreign investors will fight hard to refer to appropriate and suitable underlying legal ground to support their legal claims. Well, because either those BITs or domestic laws or customary international laws impose certain requirements on either, for example, territories, the identity of the claimants, or the territorial scope of the matters involved. So party will find it difficult to choose the appropriate applicable law. So that's litigation. And last, we will turn to investment arbitrations. Investment arbitration perhaps is the most prevailing mechanisms as it is provided in most bilateral investment treaties. And among those bilateral investment treaties, it is usually required for protection and security to foreign investors, though the degree of protection varies as determined by different arbitral tribunals. There is also the issues of compensations. Specifically, different arbitral tribunals may apply different arbitral jurisprudence in terms of what items should be compensated. Also, the compensation standard for foreign determined by arbitral tribunals are diverse. So if one single foreign investors turn to different arbitral tribunals, they may achieve different results. There is also the problem in relation to recognition and enforcement of ICEIPI awards. As clearly provided in the ICEIPI conventions, that domestic laws in relation to state immunity from execution will still applies. So that's another challenge after that the foreign investor will face after they attained a favorable ICEIPI award. So this is a brief about my research, and I should point out that my research is based on a broad viewpoint. Each of these mechanisms deserved in-depth studies. And once again, I would like to thank you for watching these videos and I wish you good luck. So that's it. Bye-bye.